My name is Ravi. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the second part on a four-part series on res gestae. And in this part of the program, we will consider broadly four topics: the birth of the concept of res gestae, the development of the concept of res gestae, how to identify res gestae, and what in fact could be established through res gestae. That is a topic that we will expand in the third part of the program. Primarily, here we will consider the birth of the concept and the development in particular. It is the case of Bedingfield, as I understand, introduced the concept of res gestae. Res gestae is actually a Latin word, as we know, and as such, when interpretation of Latin to English, sometimes there could be some distortion or misunderstanding. The literal interpretation of the subject is things done at the time of an offense or a crime being committed. However, Lord Wilberforce, in the case of Ratton, identified the weakness of this interpretation. In fact, I got the authority here. Let me take you to the relevant part in his judgment. What Lord Wilberforce said is this: the expression res gestae, like many Latin phrases, is often used to cover situations insufficiently analyzed in clear English terms. In the context of the law of evidence, it may be used in at least three different ways. That gives us the clue as to why sometimes we struggle to understand and apply the concept of res gestae, because it could have several facets in it. And let's look at what is meant by section 118 subsection 1.4. In particular, the term statement emotionally overpowered by an event and the possibility of concoction or distortion can be disregarded. They are the key words. In the past, we have placed quite a bit of emphasis and importance having an assertive statement for the statement or the comment to be introduced as part and parcel of res gestae. Then Lord Wilberforce gave the reasoning. It was introduced with res gestae, and I'm going to refer to the relevant paragraph in this judgment. This is what Lord Wilberforce said with regard to the issue of res gestae. The possibility of concoction or fabrication, where it exists, is on the other hand an entirely valid reason for exclusion. So if there is concoction, fabrication, or exaggeration, yes, it's a valid reason for exclusion, and is probably the real test which judges in fact apply. In their lordship's opinion, this should be recognized and applied directly as the relevant test. Now here it comes. The test should be not the uncertain one whether the making of the statement was in some sense part of the transaction, This may often be difficult to establish. Such external matters as the time which elapsed between the event and the speaking of the words, or vice versa, and differences in location being relevant factors but not taken by themselves decisive criteria. As regards statements made after the event, it must be for the judge by preliminary ruling to satisfy himself that the statement was so clearly made in circumstances of spontaneity, involvement in the event, that the possibility of concoction can be disregarded. Conversely, if he considers that the statement was made by way of narrative of a detached prior event, so that the speaker was so disengaged from it as to be able to construct or adapt his account, he should exclude it. And the same must in principle be true of statements made before the event. The test should be not the uncertain one whether the making of the statement should be regarded as part of the event or transaction. This may often be difficult to show, but if the drama leading to the climax has commenced and assumed such intensity and pressure that the utterance can safely be regarded as a true reflection of what was unrolling or actually happening, it ought to be received. The expression res gestae may conveniently sum up these criteria, but the reality of them must always be kept in mind. It is this that lies behind the best reason of the judge's ruling. There you are. What you look here is not necessarily only the time, but you look at a whole host of other facts. The timing is important, but was the person emotionally overpowered to avoid the possibility of concoction, fabrication, exaggeration? If there is evidence to suggest that there was, then of course the learned judge will rule the evidence out. But where it is not, the court should receive it. So don't look at the problem with blinkers on, saying, oh, the comment came several hours later of the incident, and therefore it can't be res gestae. No, it doesn't apply like that. There could be very valid reason for the statement to be made several minutes or hours later. We will look at that when we look at cases like Barnaby later. This case was approved by the leading authority right now is Andrews, and basically overruling the case of Bedingfield. The leading judgment in the case of Andrews was given by Lord Ackner, and in essence his lordship gave 5 signposts for us to bear in mind when we consider the issue of res gestae. In summary, they are: can the possibility of concoction, distortion be disregarded, which we looked at through Lord Wilberforce's judgment. Then look at the circumstances. Again, Lord Wilberforce also mentioned spontaneity. That's the third principle. Here, look for special features in the case. This is why I said that even several hours could come still within the time frame for the purposes of res gestae. That all depends on the circumstances. Say for instance, if a domestic violence takes place, a classic example, domestic violence takes place during the pandemic. People can't go out. There's the victim at home with the assailant. The victim cannot ring the police because the assailant is there. Then it is only several hours later, he goes to the local shop, during which time the complainant is able to call the police and report the matter. Still in that, say, historical moment. Now, would it be fair to rule that out on the basis, well, you rang the police 3 hours later, so you had enough time to fabricate? No. Look at the special features. Then, the possibility of error. Could there be a possibility of an error? With regard to possibility of an error, that itself is not grounds for the learned judge to exclude the evidence. The possibility of error goes to the weight of the evidence. It is a matter for the jury to consider, for the tribunal of fact to decide. And also remember, this is very, very important. I know I'm being told by some of my colleagues that at least one magistrate court thinks that if there is res gestae, the witness need not be called. No. The witness still have to be called. Before I go any further, let me remind ourselves with regard to what Lord Acton has said in these 5 probandas. This is what Lord Acton said. The primary question which the judge must ask himself is, can the possibility of concoction or distortion be regarded? Remember, therefore, the issue of res gestae is a legal issue for the judge to decide before it is being admitted. Do not agree that there is res gestae. Test it before the bench, be it in the Crown Court or in the Magistrates' Court. It may very well be that it will not fall within the parameters of this definition. 2. To answer that question, the judge must first consider the circumstances in which the particular statement was made in order to satisfy himself that the event was so unusual or startling or dramatic as to determine the thoughts of the victim, so that the utterance was an indicative reason of the event, thus giving no real opportunity for reasoned reflection. In such a situation, the judge would be entitled to conclude that the involvement or pressure of the event would exclude the possibility of concoction or distortion, providing that the statement was so made in conditions of proximate but not exact contemporaneity. This is why I gave the example of the domestic violence during the pandemic. You look at all that, the entire situation. Third point, this is spontaneous issue. In order for the statement to be sufficiently spontaneous, it must be closely associated with the event, which has excited the statement that it can be fairly stated that the mind of the declarant was still dominated by the event. Thus, the judge must be satisfied that the event which provided the trigger mechanism for the statement was still operative. The fact that the statement was made in answer to a question, but one factor to consider under this heading. Again, I go back to the issue of domestic violence. If the complainant in that example that I discussed was being bullied, being assaulted over a period of time and still suffering from basically emotionally being drained. Would it be fair 3 hours later that the victim is calling the police? No. Why? Because the situation was still operative in the mind of that person. Therefore, in that example I'm trying to elaborate on is where the victim would not have had the opportunity to sit down and concoct a story or fabricate one. Then the fourth point, apart from the time factor, there may be special features in the case which relate to the possibility of concoction or distortion. In that instant, the defense relied on the evidence to support the contention that the deceased had a motive of his own to fabricate or concoct, namely malice, which resided in him against O'Neill and the appellant, because, so he believed, O'Neill had attacked and damaged his house and was accompanied by the appellant, who ran away on a previous occasion. The judge must be satisfied that the circumstances were such that, having regard to the special features of malice, there was no possibility of any concoction or distortion to the advantage of the maker or the disadvantage of the accused. So there you look to the special features. As to the possibility of error, this is point number 5. As to the possibility of error in the facts narrated in the statement, if only ordinary fallibility of human recollection is relied on, this goes to weight to be attached and not to the admissibility of the statement, and is therefore matter for the jury. However, here again there be special features that may give rise to the possibility of error. In the instance case, there was evidence that the deceased had drunk to excess, well over double the permitted limit for driving a motor car. Another example would be where the identification was made in circumstances the trial judge must consider whether he can exclude the possibility of error. So if it is a question merely going to the weight of the evidence, judge has no power to exclude. It is a matter for the jury, in essence. What is very important for me to emphasize here, what Lord Ackner said with regard to the witness must be called. You cannot substitute a res gestae statement for live evidence from the maker of that statement. This is what Lord Ackner said. I would, however, strongly deprecate any attempt in criminal prosecution to use the doctrine as a device to avoid calling where he is available. The maker of the statement, thus to deprive the defense the possibility to cross-examine him, would not be consistent with the fundamental duty of the prosecution to place all relevant material facts before the court, so as to ensure that justice is done. That really emphasizes the importance of not allowing res gestae just to be admitted, because the prosecution says that it is res gestae. Even if it is res gestae after arguing the point before the judge, the witness must come to court and give evidence. Otherwise, that failure will put the decision in foul of this judgment by Lord Ackner, and also will breach Article 6.3, right to a fair trial, and the right to confront. All that will come into play. And it is important to bear that in mind. If I'm to expand on that, I would like to very briefly consider what could be said by the learned judge in the way of directions to the jury. It is always for the jury to decide what was said if they are sure that the witness was not mistaken in what they believe had been said to them. Secondly, the jury must be satisfied that the declarant did not concoct or distort to his advantage and to the disadvantage of the accused. And where there is material to raise the issue that he was not activated by malice or ill will. Thirdly, the jury should consider where there are special features that bear on the possibility of mistake, then the jury's attention must be drawn to consider those matters. It is important that we all bear that in mind. Let's look at the next point. What are the key elements of the section on res gestae? Rule 4. Any rule of law under which in criminal proceedings a statement is admissible as evidence of any matter stated if a. the statement was made by a person so emotionally overpowered by an event that the possibility of concoction or distortion can be disregarded, which we looked at in quite detail now. It doesn't talk about any time limits. All what it talks about was the person emotionally overpowered by the event. So the possibility of concoction or distortion can be disregarded. That's the important part. Next, what is the significance of emotionally overpowered by an event? If a person is emotionally overpowered in a hysterical situation, is that person really going to sit down and concoct a story? Would a dying man will make a false allegation against somebody that who didn't put the knife in him just because they had a bit of an argument some years ago? Or would the dying person more likely to be telling the truth as to who is the assailant on this occasion? The whole concept there is based on the person is unlikely to be concocting a story if that person was so emotionally overpowered because of the event. However, we'll look at the next few slides, then we might have another angle to this. The next question is it crucial that the relevant person does suffer from being emotionally overpowered by the event to establish that there was no concoction? Is it always necessary? No. Because there are some people who might not have even realized what has happened. The authority on the point is QD. This is a case from Northern Ireland, and the allegation was that a 2.5-year-old child complained that the defendant did something. It didn't come as a complaint to the mother, but that is what the child basically said, this has happened. And There was evidence to suggest that the defendant has been acting strangely, and eventually the case came to court and the defendant was convicted. The child didn't give evidence, but the mother did. And what the mother was told by the child was admitted in evidence. And that was, in essence, admitted as res gestae. The Court of Appeal dismissed the appeal from the defendant and said that the child's statement was properly admitted in the interest of justice. But I'm sure the issue was res gestae too. In fact, I have the authority here, and the court took the will. Being such a young child, the child would not have realized the assault that had taken place on him. So therefore he would have been disinterested, completely unaware. Consequently, the child would not have been emotionally distressed because the child doesn't know. And as such, he was so innocent. The child has replied to the mother in response to a question, but it was a non-leading question. There was evidence from the mother that she has not misunderstood what was said. And the mother was available to be cross-examined. Therefore, the learned judge was correct to have allowed the evidence to be admitted, as he was satisfied the possibility of concoction or distortion can be disregarded. Equally, the court found the child, in essence, has reported the matter or told the mother fairly soon after the event, and that there was other powerful evidence in the case. Now, it is interesting to note that one can say with confidence there, the person, just because not emotionally overpowered by the event, is not a reason in itself to exclude the evidence. For example, there could be a case where somebody could be groping, say in a busy, crowded place like a tube train. And the person who's been assaulted may not realize that is what is happening. Might think is because of the amount of people in the carriage, that somebody is just against them. But there could be another situation where there is evidence that person has done that, and it could come as a result of in those circumstances. So do not think that just because merely there is no emotional feelings that res gestae is not applicable. To this extent, I would have thought the words of Lord Acton in the case of Andrews, where you look at the special features, could come into it. The child's young age, here would be a special feature, because the child would not know any better. Now, why did a rape case where the complainants were, if I recall correctly, 6, 5, and 4 years old, or possibly little even younger? One of them described ejaculation as milk. None of the children who had suffered the sexual assaults over a period of time never said anything to the mother, because they were unaware what was taking place, and it was just pure chance. One day one of the children talked about, and it would have been ludicrous for me to have argued bitterly that it should not be allowed in, because the events, at least some of the events, were some time ago. But nonetheless, they were happening on a regular basis. And given the young age of the children, they were not really emotionally overpowered by what was happening, because they were none the wiser. In this situation, could the Court of Appeal have allowed the statement as res gestae? When you look at the authority of Andrews, it is quite clear how and what you look for. And I'm not going to go on it all over again at this juncture. The next is a question to ask is, what is the difference between the authority of QD and another authority by the name of Nye, Brain, and Nicholas? Here, we looked at the evidence, the facts of QD. In the second case of Nye and Nicholas, is that there was a collision. The victim got out of his car, went out to look what the damage is. He was assaulted and being punched. He got back into the car. He was trying to recover, and then he was threatened again, if we did not move the car, that he will be assaulted. Police were summoned and the police arrived. No sooner the police arrived, the victim identified his assailant, and both were arrested. That is, the assailant and his passenger who was in the car, and they were both charged eventually. The identification of the assailant was adduced in evidence, and the issue arose as to whether that was properly admitted. The court said yes, it was properly admitted, because the complainant, Mr. Lucas, was recovering from being assaulted. He was not in a state of being assaulted to sit down and concoct who did the assault, who did the threats. So there you have two different scenarios. In the case of QD, the child was even unaware. Here, in the case of Maya and Nicholas, the complainant was in a still state of a shock and trying to recover. For different reasons, there is hardly any difference in the way that it can be applied. Next is to look at section 118 subsection 4b. The statement accompanied an act which can be properly evaluated as evidence only if considered in conjunction with the statement. Now, there, what is meant by the statement accompanied an act which can be properly evaluated as evidence only if considered in conjunction with the statement. Going back to the case of Bedingfield and Tepper, it could be that two different people are involved in this statement being made. It could be that where someone is performing an act and stating what is taking place, but it could be equally two different people. For example, let's go back to the case of Nye and Bryant, which we looked at earlier. Now there, it wasn't the victim who rang the police. It was the local people who saw what was taking place, called the police. But when the police came, it is he who did the identification. Now equally, it could be that somebody else could be giving a running commentary of an event taking place against another person. Let's say, for example, a bank robbery. Bank robbery is taking place and the bank clerks are being held at gunpoint. And a passerby notices what is happening and gives a running commentary. That could amount to res gestae. The next question that I would ask is there an obligation to consider the interest of justice factors in applying the rule of res gestae? The answer is no. This is not a case where you need to consider that. You look at other safeguarding points that are mentioned in Lord Acton's judgment. Equally, is there a need to serve notice to adduce res gestae? When you look at criminal procedure rules, rule 34.2, there is no requirement to give such notice. But both parties, in my view, should be ready to argue the point of res gestae. Otherwise, it could be quite catastrophic, because things will just be admitted, and almost always will be. It's a hearsay statement or self-corroborating statement. What is the procedure for applying the rule? If we looked at the authority of Lord Acton's judgment in the case of Andrews, it is quite clear that you cannot substitute live evidence, the duty to call a witness to give evidence, by introducing res gestae. That is not the purpose of res gestae, because to do otherwise would be to deny the defendant the opportunity to cross-examine the complainant. So therefore, he should be allowed the opportunity to cross-examine the person. Talking about the case of Tepper earlier, just very briefly, I'm not sure whether I covered that earlier, so I'll cover it here. This was a case where an allegation of fraud was the issue in court, and the police officer gave evidence to the effect that some minutes after the property of the defendant being on fire, that she heard a woman who was not identified, not called to give evidence, saying that your shop is burning and you are running away from the place. And this was some minutes later. The Crown adduced that evidence and he appealed on it. And the Court of Appeal in that instance held that it was inadmissible. Now this is a good example to compare with the case of Q and D, Bryan and Nichols earlier, which we looked at, and the need to call witnesses to give evidence. The authority of Edwin and Wells will highlight the issue, and the case of Nicholas Toby. In fact, I will read the relevant passage. This is where road traffic accident took place with a car and a coach. Several minutes later, the police arrived at the doorstep of the defendant. The coach driver was with the police officers. When the door was opened, the coach driver pointed at the defendant and said, "That's him who was involved." He said it was not him. Basically, he said it was his wife. And his wife said, "Don't make things worse, I didn't drive." When he was eventually breath tested and charged, he appeared in court and the case went to trial. When the matter came to trial, the prosecution had failed to warn the coach driver, and it was held, although that the sergeant who carried out the drink drive procedure was there to give evidence, that without the evidence of the coach driver, that cannot take place, because there was no other evidence to suggest that the defendant was the driver. In particular, he having denied it when he was challenged, and he didn't call any other witnesses, very wisely too, and the drink drive procedure had been out of order, so therefore they had to use the blood sample. The blood sample test was provided to the defendant on the day of the trial, which was defective because it must be served at least 7 days prior to the date of trial. Consequently, that could not be allowed. Therefore, the case was dismissed. There are other recent authorities on the point of the need to call witnesses to give evidence, and it is imperative, in my view, that the defense advocates is aware and ready to argue. One, is the material that is in issue falls within the ambit of res gestae? Two, if it does, then ask the witness to attend court, without which the defendant will not be given a fair trial. And next we will look at the issues of emotional state and under which what can be said by way of res gestae. In other words, what section 118 subsection 4c allows you to introduce, and they are generally physical or mental sensation, intention, no emotions. But what you cannot do is to adduce the cause of that. So we will expand on this topic in part 3. Thank you very much for joining me for this part of the program. I hope it has been useful. Thank you for your valuable time. God bless.